All right, each side will have 15 minutes, and you as the appellant may reserve up to 5, and just need to let me know if you want to reserve some time for this.
Thank you, Your Honor. Attorney Sean Buchanan on behalf of the appellant. I would like to reserve 5 minutes. I am not checking my email. I assure you.
That's fine.
I'm making sure I stay on track on my time. Attorney Sean Buchanan on behalf of Rhoda and Nero. I believe this is a relatively simple appellate case for the first assignment of error. We are asking the court to review the summary judgment granted by the trial court for no triable issues of fact. We do believe that the fact that the inspection that is in the record occurred prior to the Northeastern Ohio winter did create a triable issue of fact for a jury. Regardless of expert testimony, we believe that the effects of outdoor wood and outdoor common areas through the winter would be common knowledge for our juries here in Ohio, and I think that did create a problem for the defendant with the negligence standard, and that I don't think you can reasonably rely on a pre-winter inspection to tell you that your outdoor common areas are still good in the summer, as that's essentially when the damage occurs, and that doesn't require expert testimony to present that. That's the nature of living in Ohio.
So you made reference to this HUD inspection,
yes,
but didn't tell us anything about what it said.
The HUD inspection did say that the stairs were good at that point, and that was the inspection referring to as prior to the winter. And I think that inspection does give the defendant some defense, obviously, but I don't think you can rely on a pre-winter inspection for a summer accident in the state of Ohio due to the winters that we have. I mean, that's essentially when the damage to an outdoor common area would occur. And I think the court relied on that as saying, look, they've done the inspection, what more could we have asked of the landlord? And I believe that is incorrect in the summary judgment standard.
Well, I think the court also said that that they present evidence that they had some type of schedule for looking at the premises, inspecting them, whatever you want to call it, and that you have not alleged that it was unreasonable or that there should have been a different type of inspection.
Well,
different schedule of inspection.
They did present an affidavit from a property manager that said we do inspections. It was a conclusory affidavit that contained no specifics as to the inspections of the stairs in question, nor as to the schedule of the inspections. It was just, we do our job, and I don't believe that type of affidavit is sufficient to grant summary judgment.
Well, there's nothing under the law that requires them to do like a semi-annual inspection after a winter, every month, every 2 months, right? Right.
There's no strict requirement, but it is the appellant's view that would have been a question for the jury. It's not a per se negligence. Now, as for the second assignment of error, I would note as an introductory matter that this court decided Mark T. Cluckus versus Route 80 Express recently, in between the briefing of this case and today's argument. I believe the Cluckus v. Route 80 Express is an on-point case because it deals with the exact same issue where the court granted a global summary judgment that didn't...
Could I stop you just for a second?
Yes.
Did you file a motion to supplement your arguments to additional authority?
I did not.
Okay. We have local rules that cover this exact same thing so that the other side is not put at a disadvantage and is not able to respond to. So really we can't hear argument in regard to that case because you need to supplement your argument so that the other side has the opportunity to respond as well.
Okay. And it's still, I would still argue that the court erred in disposing of count 2 on a summary judgment motion for negligence, as count 2 is a separate count from count 1, which is the negligence count. Count 2 does not deal with negligence. It doesn't allege negligence. It exists as a contract count alleging that the contract, which for HUD houses includes safety provisions, was not followed as to the safety provisions. It's a separate analysis. That analysis was not in the original motion for summary judgment, and then the court simply disposed of it as a footnote saying that the, well, now appellant, but in that case plaintiff, had essentially waived it by not responding to it in summary judgment. Our view is that if the defendant in the trial level doesn't adequately brief it in summary judgment, doesn't argue for it in summary judgment, doesn't mention contract in summary judgment, we have no responsibility to respond to it in summary judgment because they haven't done it. And we would ask that the case be remanded for one of those two reasons, either for the global summary judgment or the summary judgment solely as it relates to count 2, which sounded in contract. Thank you, Your Honor.
Thank you, Your Honors. My name is Joe Oldham on behalf of the defendants in this matter. I don't really have a whole lot to add. Happy to address any questions you may have. I would point out, I suppose, listening to appellant's argument, that if you take what he says in relation to the inspections, it would be impossible to ever get summary judgment, because basically what they're saying is, well, you didn't do enough inspections, or they weren't reasonable, and it's a question of fact. We could have done an inspection a week before, and as well, it's a jury question whether you should have inspected again. And the affidavit in this case said that they did do reasonable inspections. What was attached was the last HUD inspection, which was 9 months before, but there were in fact other inspections, and if the argument's going to be that they weren't sufficient, I would think they would need to support that with, some deposition testimony or affidavits, rather than just a blind argument that, well, it just wasn't enough, or it's a question of fact. I don't think that's what the law is.
What about the allegation that the matters set forth in the affidavit were not factual, but rather they were conclusions? We haven't looked yet at the affidavit.
The affidavit says that there were reasonable inspections concluded, and I believe it, I can't remember, Your Honor, if it attached the actual HUD inspection, but it said, on behalf of the landlord, we do reasonable inspections.
Well, that and it sounds like that's the very nature of a conclusion, rather than factually saying, this is what we do. We do this, we inspect that, and then leave it to the trier of fact, or, to determine whether or not, after looking at those facts, that those are, in fact, reasonable.
Right. Well, there was the actual HUD inspection, which was 9 months before, and there was no, in response to that from the other side, it was simply, well, that's not enough. They didn't have anything to say to counter that. I think we met our burden of proof by saying we do reasonable inspections on the property. I believe probably not proper to argue here today. I actually supplemented an affidavit from the handyman, but it was, I think my timing was I filed it. I didn't know that summary judgment had been actually granted, but I did supplement with an affidavit from him saying I'm out there all the time. Every time I'm out there, I look at the steps, make sure everything's reasonable versus true formal inspections.
But you don't think that's in the record?
I don't. I know it was filed, but I don't know if it's in the record that you got, and it wasn't probably formally in the record at the time the summary judgment was granted.
Which means we wouldn't consider it in any way.
I think that's correct.
Okay.
Right.
What about in relation particularly to negligence per se? What, if anything, did you relate in your summary judgment motion to that?
Well, in the summary judgment motion, I set forth what the standard is in the landlord-tenant situation, where it's did you keep the premises in a fit and habitable condition, or were they aware, or should they have been aware of any defects with the property? And in relation to this case, the plaintiff, who is a tenant, testified in her deposition, which is in the record, that whenever she had a complaint with the property, it was immediately addressed. Any complaints were addressed, that she was not aware of any problems with the steps. She used the steps regularly. She wasn't aware of anybody else having a problem with the steps. And when I moved for summary judgment, I didn't say only as to count one. I just addressed what the standard is for landlord-tenant. It was my belief I was moving for summary judgment on the entire complaint. I didn't say only as to count one. The counts in the complaint are not really set forth. It doesn't say. To me, they both sounded in landlord-tenant, which is what I addressed in the summary judgment motion.
Well, I understand what you're saying, but in the second count, it does say that about the lease, and he had a duty to, under the lease itself. It seems like he's arguing that aside from what the state of Ohio puts on the landlord as his requirements, he had an independent duty based on the nature of this particular lease.
And I don't think a contract or any lease was actually attached to the complaint.
Does that matter?
Well, to me it does. I mean, it was not addressed at all in response to the summary judgment motion on the entire complaint. It wasn't like I only said I'm moving as to count one and not as to count two. There was no reply at all. And the only arguments that were ever brought up as to negligence or any violation was that they didn't do enough inspections, which I've addressed, and that photographs that they produced that were taken after the inspection to say, well, therefore here's how it must have looked before, which I addressed in my brief, but that's, I think, clearly something that has to be subject to expert opinion to say, number one, whether there was any rotten wood, or number two, how it would have looked beforehand. You can't take something afterwards and say, well, it must have looked bad beforehand. That would, all the jury could do on that would be speculate. You'd have to provide some evidence to say, some expert to say, yeah, if this looked like this now, before it would have, it should have been visible or would not have been visible, but you can't just let a jury speculate. So, Your Honor, I think to answer your question, those were the only two arguments ever presented as to what, how the plaintiff could recover in this case.
Thank you. Well,
anything else?
I don't believe there are any questions from the panel, so.
Thank you very much.
Thank you. Counsel, you two have 2 minutes remaining.
Your Honor, I would just briefly note, as to the photographs, I don't believe expert testimony was required. The photos were admitted as taken recently after the fall occurred, and I don't think we're asking that anyone needed to know what the stairs would look like in January. We're talking literally what did they look like right before they fell. I think that is within the purview of the jury to say rotted wood, it looks like rotted wood 2 or 3 hours previous. So I don't think we needed a biologist on wood degradation or something like that to testify as to how they would have looked 3 or 4 months prior. So if there are no further questions from the panel.
Thank you.
Thank you, Your Honor.
Thank you. The court will take the matter under advisement. A written opinion will be sent to both sides, as well as you can look on our website and the Supreme Court website where we release our opinions electronically. Thank you.